Good evening. I'm Jim Duff, the Executive Director of the Supreme Court Historical Society, and it's my honor to welcome you tonight to the resumption of our series, Civics and American Democracy. Tonight's lecture will focus on the historic origins of an independent federal judiciary. We thank also our partners at the Justice Kennedy Library and Learning Center at the Sacramento Federal Judiciary Library and Learning Center Foundation, as well as the Judicial Learning Center for the Eighth Circuit, based in St. Louis, Missouri. Our Historical Society was founded in 1974 by then Chief Justice Warren Burger to improve public understanding about the Supreme Court, the Constitution, and the judiciary. To that end, the Society's series on civics and American democracy has been an opportunity to highlight the importance of an independent federal judiciary and its crucial place in our American democracy. If you missed an earlier program, we encourage you to visit the Society's YouTube page to watch them. You won't be disappointed, and tonight it will be another very informative discussion about the origins of judicial independence. Tonight's speaker is Professor Scott Douglas Gerber. He is a professor of law at Ohio Northern University and associated scholar at Brown University's Political Theory Project. He received both his PhD and JD from the University of Virginia and his BA from the College of William and Mary. He's had a lot of experience in Virginia. He clerked for U.S. District Judge Ernest Torres of the District of Rhode Island. He is the 2002, 2009, 2011, and 2012 winner of the Fowler V. Harper Award for Excellence in Legal Scholarship. He has served on the Ohio Advisory Committee of the U.S. Commission on Civil Rights since 2008. Scott was elected to the Executive Committee of the AALS's section on Constitutional Law in 2022. He teaches constitutional law and American legal history. He's a well-respected authority on the Declaration of Independence, and he has published 2 books on the subject, To Secure These Rights, the Declaration of Independence and Constitutional Interpretation, and also the Declaration of Independence, Origins and Impact. His edited collection, Seriatim, The Supreme Court Before John Marshall, was called by our own Supreme Court Historical Society Quarterly, quote, a wonderful book destined to be a staple source for the court's first decade. Professor Gerber spent the 2009 and 10 academic year on sabbatical at Brown University's Political Theory Project, where he completed A Distinct Judicial Power, The Origins of an Independent Judiciary, 1606 to 1787, from which tonight's lecture is drawn. He recently completed a book entitled Law and Religion in Colonial America, The Dissenting Colonies that Cambridge University Press is publishing in July this year. With that, we'll turn it over to Scott and Professor Gerber. Welcome. Thank you so much for being with us, and we're looking forward very much to your lecture this evening.
Thank you, Jim. I have a PowerPoint that I will now put on the screen. So can you see that?
Yes.
Okay. Well, I would like to thank the U.S. Supreme Court Historical Society for inviting me to talk with you this evening, especially Executive Director Jim Duffy, who just gave those nice introductory remarks, and Director of Programs Jennifer Lowe. An independent judiciary is now a familiar foundation of American constitutionalism. Chief Justice John Roberts frequently extols the importance of that principle in his annual reports on the state of the federal courts. Other members of the nation's highest court have expressed similar views over the years. As Jim mentioned, my topic this evening is the historical origins of an independent judiciary, and the book draws from my Oxford book, A Distinct Judicial Power. It takes a long time to write a book, especially a book about legal history. And I'm always curious about why authors pick the topics they do. In my case, I just finished writing a book on Justice Clarence Thomas's jurisprudence, and I was thinking about what to take on next. I kept coming across stray comments here and there by Gordon Wood, the preeminent historian of early America, that someone needs to write a book about the origins of judicial independence in the United States. Professor Wood said so 5 decades ago in his magisterial, The Creation of the American Republic, and he said so many times thereafter. He issued his most detailed statement on the matter in an endowed lecture at Suffolk University Law School. And this is what Professor Wood said in pertinent part, quote, "The story, amazingly, has never been told. For all our studies of the Supreme Court and its great decisions, we have no history of the emergence of the independent judiciary at the end of the 18th and beginning of the 19th century, perhaps because we take a strong independent judiciary so much for granted. It's a remarkable story, one of the great political and cultural transformations in American history, and it was accompanied by one of the great propaganda efforts in our history to get people to believe that judges appointed for life were an integral and independent part of America's democratic governments, equal in status and authority to the popularly elected executives and legislatures, was an extraordinary accomplishment and one to which many contributed in the decades following the revolution." Close quote. Given that the subject, at least as I conceived it, married 3 intellectual interests, law, history, and political theory, I decided to give it a try. The result, some 10 years later, was A Distinct Judicial Power, a book that chronicles how the original 13 states and their colonial antecedents treated their respective judiciaries. The focus is on when and why the state judiciaries became independent. Of course, the federal Constitution drafted in 1787 made the federal judiciary independent. The federal courts form a separate branch of government. Federal judges are afforded life tenure during good behavior, and a federal judge's salary cannot be diminished while he or she is in office. The principal aim of A Distinct Judicial Power is to shed light on the federal model by exploring the experiences of the original states. My objective, quite simply, is to identify the origins of Article 3 of the U.S. Constitution. I leave it to others to decide whether Article 3 articulates the ideal model of judicial independence. After all, the majority of states now elect their judges, and only Rhode Island follows the federal example of life tenure during good behavior. Moreover, as I'm sure the audience is aware, there have been increasingly vocal calls in the last couple of years to reform the Supreme Court by, for example, abolishing life tenure for the justices. The first part of the book examines the political theory on which an independent judiciary was based. It traces the intellectual origins of a distinct judicial power from Aristotle's theory of a mixed constitution to John Adams's modifications of Montesquieu. And the book's title, A Distinct Judicial Power, comes from Adams's famous 1776 pamphlet, Thoughts on Government, that I'll speak more about in a moment. This intellectual origins is a complicated story, but one that needs telling. I also described the debates during the framing and ratification of the federal Constitution about the independence of the federal judiciary. As Alexander Hamilton put it in the Federalist Papers, quote, "The complete independence of the courts of justice is peculiarly essential in a limited constitution." A number of years ago, I was asked to summarize for a law journal symposium the political theory on which an independent judiciary is based in 500 words or less. And so what I'm going to do is I'm going to read you that, and then I'm going to focus on John Adams. So this paragraph is quite dense, so just bear with me, if you will. Government institutions do not spring fully formed from the pen of constitutional framers, like Athena from the brow of Zeus. They develop over time, and they are shaped by political theorists. The judicial institution embodied in the US Constitution is no different. The political theory of an independent judiciary is the culmination of the work of 8 political theorists writing over the span of 22 centuries, with each building on the contributions of the others. It all began with Aristotle's theory of a mixed constitution, a theory that divided government into 3 parts, with each part representing a political class of the regime. Next came Polybius, who emphasized the checking and balancing of government power, albeit power still divided along class rather than institutional lines. Marsilius of Padua was the initial political theorist to focus on the function of particular institutions, while Sir John Fortescue was the first to appreciate the unique role of the judiciary. Gasparo Contarini was responsible for marrying the Aristotelian theory of a mixed government to the concepts of checks and balances. And King Charles I took the pivotal step of committing Anglo-American constitutional theory to the notion of balance among political institutions rather than dominance by one. Montesquieu contributed the most famous idea of all, that political power should be divided among the legislative, executive, and judicial branches of government so as to ensure the people's liberty. Finally, John Adams argued that judges, and not simply temporary juries, as Montesquieu had argued, need to be independent from the executive and legislative branches, and that this independence will be possible only if they were afforded tenure so long as they behaved well and were paid adequate and stable salaries. In sum, although political architecture is not solely the province of political theorists, without political theory, Americans' constitutional framers could not have used the lessons of history to create a judicial branch whose independence plays such an essential role in the preservation of freedom. And that's John Adams. Time constraints permit me to expand on only John Adams's contributions to the political theory of an independent judiciary. But that's okay, because Adams's contribution is the one most relevant to tonight's discussion, because Adams created the political architecture that the framers memorialized into Article 3 of the US Constitution. John Adams was the American founding's most sophisticated political theorist. And when he modified Montesquieu's conception of the separation of powers by developing what can be fairly termed the political architecture of an independent judiciary, he articulated an idea that helped make judicial review possible. And judicial review, that is, the court's power to void a law enacted by the legislature or the executive for violating the Constitution, it is what gives the court its power. Adams had been writing about the need for an independent judiciary since at least January and February of 1773, when he engaged in a series of exchanges on the matter in the Boston press with William Brattle. Brattle, a Tory, insisted that the proposed payment of judicial salaries by the Crown should not concern the people of Massachusetts Bay, as the judges of the colony's superior court, like their brethren in England, enjoyed life tenure so long as they behaved well. Adams, after conducting an extensive historical review of the subject, countered that Brattle was wrong to claim that judges in England, let alone in America, held their offices during good behavior. Consequently, the proposed control by the Crown over judicial salaries was perceived by Adams as an additional threat to the independence of the Massachusetts judiciary. Adams revised and revisited his thoughts on an independent judiciary in the famous pamphlet that's on the screen there, Thoughts on Government, published in 1776. The pamphlet, a clarion call for the separation of powers, written in response to Thomas Paine's recommendation in Common Sense that all government power be vested in a unicameral legislature, explains in no uncertain terms how important an independent judiciary is to any form of government dedicated to the preservation of liberty. Adams writes, quote, "The dignity and stability of government in all its branches, the morals of the people, and every blessing of society depends so much upon an upright and skillful administration of justice that the judicial power ought to be distinct from both the legislative and executive and independent upon both, that so it may be a check upon both, as both should be checks upon that." Adams argues in his pamphlet for more than merely making the judiciary a separate branch of government. He also calls for stable judicial compensation and tenure so long as judges maintain good behavior. Quote, "They should hold estates for life in their offices, or, in other words, their commissions should be during good behavior and their salaries ascertained and established by law. Judges who misuse their offices should be impeached by the House of Representatives before the governor and council, and if convicted, should be removed." The U.S. Constitution of 1787 excluded the executive from participating in the impeachment process, but otherwise contained principles identical to Adams's proposal. As David McCullough put it in his Pulitzer Prize-winning biography of Adams, quote, "Little that Adams ever wrote had such an effect as his thoughts on government." The bulk of a distinct judicial power isn't about political theory. What it does, it chronicles how each of the original 13 states and their colonial antecedents treated their respective judiciary. This portion, presented in 13 separate chapters, brings together a wealth of information, charters, instructions, statutes, and so on, about the judicial power between 1606 and 1787, and sometimes beyond. In the apt words of legal historian John Philip Reed, quote, "American histories of judicial independence invariably begin with origins in the federal courts and pay slight or no heed to what was happening in the states. That is a mistake." The subtitles to each of the 13 chapters about the individual states are meant to highlight an intriguing aspect of the particular state's judicial history. For example, the subtitle to the Maryland chapter is "Chancellor Theodoric Bland and Salaries that ought to be secured. Now, this slide's going to be somewhat difficult to read. I'm going to try to see if I can blow it up a little bit, and I'll just mention what it is. This is a table in my book that brings together all of the 13 original states and how the judicial power was treated in their various constitutions. And obviously, a couple of the states had more than one constitution. So what the book also does is chronicle how before the American colonies declared independence from England, there were hints of judicial independence in almost all of the colonies. What a historian who read a draft of my book colorfully termed a groping towards it. And I'll give you a taste of that now. For example, by the mid-17th century, Virginia's justices of the peace had claimed and exercised the right to fill vacancies in their respective courts, which made the county courts self-perpetuating and for all practical purposes independent of the executive. John Winthrop's famous journal recorded a 1644 statement of the church elders in Massachusetts Bay that, quote, there is a threefold power of magisterial authority: legislative, judicial, and consultative or directive. In April of 1769, New Hampshire Governor John Wentworth, after a protracted debate, convinced the legislature to pay appeals court judges. Connecticut settlers expressed concern on a number of occasions prior to fleeing Massachusetts about the abuse of judicial power in the Bay Colony that resulted from the absence of written laws. North Carolina Governor Gabriel Johnson dissolved the legislature in 1740 rather than permit it to remove Chief Justice William Smith from office. As early as the 1690s, South Carolina courts seem to have invalidated legislative acts that they concluded were inconsistent with the colony's organic law. The fundamental constitutions for the province of East New Jersey of 1683, for which William Penn was at least partially responsible as one of the proprietors of East New Jersey, appeared to award judges life tenure during good behavior. In 1657, the burgomeisters of New Amsterdam, today New York City, established separate meeting days for their judicial and legislative responsibilities, and also requested permission from Director General Peter Stuyvesant that these two powers of government be exercised by two different sets of men. Pennsylvania's 1683 frame of government conferred tenure upon judges during good behavior, and Johann Prince, the third governor during Delaware's Swedish period, requested in 1647 that his superiors in Europe send him a secretary who could, quote, attend to the judicial business. Of course, these were only modest gestures, some more generous than others, and colonial judiciaries remained far from independent. Among the Declaration of Independence's list of grievances against King George III was that, quote, he has made judges dependent upon his will alone for the tenure of their offices and the amount and payment of their salaries. Okay, so now I gotta switch to the next slide. So there it is. So that, of course, is a map of North Carolina. Time constraints permit me to provide more detail about only one state, and I've picked North Carolina. Why North Carolina? Because North Carolina was one of the two states, the other was Virginia, that had an independent judiciary in the federal sense of the idea prior to the federal Constitution of 1787. The subtitle to the North Carolina chapter is Governor Thomas Burke and the Origins and Judicial Review, and you'll see why in a minute. Although the North Carolina judiciary did not become independent until the state's first constitution in 1776, the almost continuous conflict between the executive and the assembly over control of the courts and the political theorizing that suggested a solution to that conflict directly influenced the nature of the judicial institution embodied in the state's original organic law. Significantly, what happened in North Carolina had profound consequences for American constitutional law. In the 1787 case of Bayard versus Singleton, the Supreme Court of North Carolina became one of the first courts in the United States to exercise the power of judicial review, which is the ultimate expression of judicial independence. Moreover, a previously unknown non-judicial precedent for judicial review, a 1781 objection to a court bill by Governor Thomas Burke, suggests that North Carolina was perhaps the first state to fully appreciate the connection between judicial independence and judicial review, and I'll say something about that in a second. The first portion of the North Carolina chapter examines North Carolina's proprietary period, which was 1663 to 1728. Particular attention is afforded to the fundamental constitutions of Carolina of 1669, an organic law written by British philosopher John Locke that created not only a model of government for North Carolina, but a social and economic system as well. At the top of this complicated arrangement were the Lords Proprietors, the owners of North Carolina. All power, including the judicial power, resided with them, although they were permitted to delegate much of that power to government officers who served at their pleasure. The second portion explores North Carolina's 5 decades as a royal colony, 1728 through 1776. The dozens of instructions concerning the courts issued to the royal governors by the Crown evidenced that the Crown expected to control the administration of justice in the colony. The Assembly, however, had other ideas. In fact, the conflict in North Carolina between the executive and the Assembly over control of the courts was among the most vitriolic of any in the British American colonies. The result was a justice system in almost constant crisis. The third portion addresses the North Carolina Constitution of 1776. North Carolina was the first state to receive a draft of John Adams's 1776 pamphlet, Thoughts on Government. As I mentioned, Adams was writing in response to Thomas Penn's insistence in common sense that a unicameral legislature was best. Adams, however, emphasized the importance of separation of powers in general and an independent judiciary in particular, as we've seen. North Carolina, unlike most of the other newly independent states, adopted Adams's proposals. The North Carolina Constitution of 1776 thus contained all 3 of the central tenets of judicial independence. The judiciary was to be a separate institution of government. Judges were to serve for life during good behavior, and they were to receive adequate salaries. That's Governor Thomas Burke. Importantly, on July 25th, 1781, Thomas Burke of North Carolina evidenced his commitment to the independence of the North Carolina judiciary when he objected to a court bill that would have created a special treason tribunal, quote, composed of persons chosen at the will and pleasure of the governor and altogether dependent on him and the General Assembly. He insisted, however, that such a bill violated the North Carolina Declaration of Rights provision that required the judiciary to be a separate and independent branch of the North Carolina government. And note, a number of the early state constitutions put in their Bill of Rights that an independent judiciary was a fundamental right of the people. In short, Governor Burke objected to the bill, although he had no power to veto it, in large part because it gave him too much power over the judiciary. And this is what he said, quote, "Convinced as I am that the execution of this power would afford a most dangerous precedent, and that the General Assembly had no constitutional authority to invest me with it, and if they had, sensible as I am of the imperfections of human nature, I dare not undertake it. I feel myself under the necessity of declining the execution of a power so repugnant to my principles as a citizen of a free republic, and so contrary to my ideas of the duty I owe to the people as their chief magistrate." Governor Burke likewise recognized that judicial review was the ultimate expression of judicial independence and a necessary expression in any constitutional order committed to protecting individual rights. He argued against the court bill in question because, quote, "civil liberty would be deprived of its surest defenses against the most dangerous usurpations, that is, the independency of the judiciary power and its capacity of protecting individuals from the operation of laws unconstitutional and tyrannical." The year was 1781, not 1803, the year of Marbury v. Madison. The final part of my book, and I'm just going to mention this for about 2 minutes, illustrates that Governor Burke was correct. There I describe the influences of the colonial and early state experiences had on the federal model that followed and on the nature of the regime itself. I explain how the political theory of an independent judiciary investigated in part 1 and the various experiences of the original 13 states and their colonial antecedents examined in part 2 culminated in Article 3 of the U.S. Constitution. I also explain how the principle of judicial independence embodied in Article 3 made the doctrine of judicial review possible and committed that doctrine to the protection of individual rights. Concisely put, the risk to a judge who exercises judicial review when he or she is not independent of the executive and the legislature is either removal from the bench or reduction in salary. John Adams knew this, and so did the framers who met in Philadelphia during the summer of 1787 when they wrote Adams' theory of judicial independence into Article 3 of the Constitution. Thank you for listening. I now welcome any questions or comments that you might have. Thank you.
Thank you very much, Scott. Fascinating study about the origins of an independent judiciary, and so much of it rooted in our states, which has really been overlooked. I have a few questions of my own, and we'll certainly incorporate those from the audience that we're getting as well. You mentioned the differences between Montesquieu and Adams early on. Was Montesquieu, was he opposed or just didn't articulate a completely independent judiciary? He articulated the notion of 3 separate branches of government, but was he opposed to an independent judiciary or just didn't take that next step?
He wasn't focused on it. What he was writing about in the spirit of the law is what he thought each country was emblematic of. And so when he was describing England, He
Mhm.
thought England was about liberty. That's what England was about. And then
Yeah.
he described how it was the crown and the lords and the commons that gave England its liberty. And he noted that there were three powers of government: executive, legislative, and judicial. But he immediately just dropped out the judicial and focused on the other two. And it was Adams who brings it back up and emphasizes the judicial power. And that's
Interesting.
Adams' great contribution. And that's why I titled the book like I did. A distinct.
And Adams was fully aware of what was going on in the states when he was drafting. Why? It's interesting to me that states where the origins of judicial independence can be found, and you've demonstrated it really very clearly, I think, in your work. Why is it that now states have turned to electing judges in many instances? I don't know how the numbers break out in all 50 states, if it's a majority or not, but there are many states in which judges are elected officials. What do you think created that distinction between many of our state governments and our federal system?
That occurred primarily, the explosion was the 19th century, Andrew Jackson and the demand for democratization, and that just picked up steam. And so voters just wanted to vote for everything, including judges. And so in Ohio, we elect our judges. And so you can see TV commercials of judges essentially lobbying for votes by having their arms around police officers. And Justice O'Connor in particular was very upset about that. In my opening remarks, I mentioned how Chief Justice Roberts talks about that in his State of the Federal Courts address to Congress all the time. But Justice O'Connor, as you know better than me, started a center about it, wrote op-eds about it, because she was very concerned about it. And she thought that the federal model was preferable.
Yeah, we've done a little search here, and 38 states elect their judges and justices now, which is really a pretty remarkable number, particularly given the origins that it started in the state at the state level. You mentioned, Scott, the criteria in some of the states for adequate salaries. That's a little different, at least on its face, than no reduction in salary. Who was responsible, or what was there any one state that provided for that security against interference from the other branches into judicial independence? That is, the notion that you cannot reduce a judge's salary when they're in office.
Yeah, I'm trying. Let me go to the table in the book just to get my memory back on track on this. Yeah. Well, I think I in terms of the theory, it was Adams, because what was happening in the colonies was that if the legislature wasn't happy with what a judge was doing, they cut the pay.
Right.
And so Adams in the pamphlet says you can't do that.
Yeah.
Because you want judges to be making decisions based on law and not just based on fear of losing their livelihoods, things like that.
Right.
And he convinced some states to do that. Other states were kind of wishy-washy on it, as you noted. But Virginia and North Carolina were on all fours with it. And as I mentioned in the table, some of them had some of it right. Secure salary that can't be diminished, but they let the judges be removed by address. And that's one thing I didn't mention. And believe it or not, Massachusetts did not have a perfectly independent judiciary in its 1780 Constitution, which Adams wrote, by the way, because they permitted the English practice of removal by address, which simply means that if a majority of the legislator asks the governor to remove the judge is out.
Hmm.
And people sometimes ask, well, why did Adams do that? Well, the first constitution that he had a hand in, they couldn't pass it in the state. And so he had to compromise and give them that. And so that chapter I call the safety valve theory of
Mhm.
judicial independence. So the safety valve was this removal by address, but Virginia didn't have that. North Carolina didn't have that. And obviously Article 3 of the federal constitution does not have that. And
Right.
they did think about that in Philadelphia in the convention. They did debate that. And
Mhm.
someone wanted it and other people said no, because it was a threat to judicial independence. So and again, because of time constraints, I couldn't get too much into the convention debates and the ratifying debates.
Sure.
But they were aware of these pre-existing state and colonial practices.
Mhm.
They were aware of that.
Mm.
And I'll just give you one other example of that. Age limits.
Mhm.
Some people wanted age limits on judges, and Hamilton argued against it. And his argument was that in New York, we have it. It's 60. And I'm against it because you're losing good people that are still vigorous.
Right.
He also had another argument, but that was the main one. And one of the current reform proposals is that age limits, and a lot of states do have age limits. Ohio has age limits, for example.
Yeah.
So they were aware of all of what I talk about in the book, and they used the political theory to decide, okay, we like what Virginia and North Carolina did. And by the way, they just borrowed from John Adams.
Yeah. Yeah. Fascinating. Well, and the other thought I have, and I'll turn to questions from our audience in just a second, but one other observation I had, it's a very interesting historical perspective that you bring to this. And I don't know if you've read Judge Jeff Sutton's book on Who Decides, States as Laboratories of Constitutional Experimentation. Jeff is the Chief Judge of the Sixth Circuit at Court of Appeals now, and in your state of Ohio. An interesting study of current state courts and the Supreme Courts as being labs for constitutional experimentation, just as they were even prior to our own federal constitution.
He's coming to speak at the law school I teach at in the spring semester. So
Oh,
in a couple
good.
weeks. Yeah, he's spoken there a couple times. He's a great speaker, very bright, very
He
good on his
is.
feet.
Yeah.
Yeah. So yeah, I look forward to that.
Yeah, that'll be an interesting presentation with the two of you. Questions from the audience. Why did you start the book with the year 1606? What happened during that year?
Question. I mentioned that in one of the front matter pieces, what I call note on methodology. And so I focus on texts. I'm a lawyer and a political scientist. My PhD is in political science, trained as a historian. And so my focus on texts led me to title the book 1606, not 1607. 1607 was when Jamestown was settled. 1606, however, is when the charter was issued. So I focus on texts in it. So that's why. And I actually say that. So I'm very delighted that the reader asked that question, because I need to address that, and I do.
Good, great. Is there contemporaneous evidence that the framers, including Madison, were actually aware of Adams' pamphlet and its emphasis on an independent judiciary?
Absolutely. Absolutely. Yeah, I talk about that in the book quite a lot. For example, when Virginia was writing its constitution, Patrick Henry said, I've seen your thing. I wish you were here to help me out, that kind of thing. So yes, they were well aware of it. They were very learned. I know that long 500 words I read, kind of synthesizing 22 centuries, is quite dense. But Madison, Adams, all of those folks were widely read in political theory. If you read the Federalist Papers, they're quoting Montesquieu and things like that. And so, yes, Adams is, as David McCullough said in his biography, that was the most important thing Adams ever wrote. And it was because it was the separation of powers theory that was embodied in the US Constitution. That was why.
Good. Would Professor Gerber comment on support for an independent judiciary if it would not necessarily imply support for the right of judges to overrule legislatures? I guess the question is, would that be correct? If it's not, an independent judiciary does not necessarily imply support for the right of judges to overrule legislature. So that, I guess that's the concept of judicial review, if that's essential to an independent judiciary.
I think that what we have in our Constitution, as I'm sure everyone knows, is checks and balances, not separation of powers. If you look at the Massachusetts Constitution of 1780, or if you look at the New Hampshire Constitution of around that time as well, they describe these three powers and essentially say that they can't interfere in any way with anything else, that the executive can't infringe on the legislature, the judicial legislature can't interfere with the executive and judicial, etc. So, so the circles, the three circles don't touch. In our system of checks and balances, they overlap, checks and balances. So the president can veto legislation, so he's in the legislative function as well. And so why am I saying that? Because without judicial review, there would be no constitutional check that the judges would have on the executive or the legislature. So most folks focus on this vertical notion of judicial review. The Constitution is higher law, statutes are inferior law. What I focus is on the horizontal, right? The check that our coordinate and independent branches of government have on each other. And so without judicial review, there would be no constitutional check possessed by the judiciary. And again, in my book, I explain all of that. I quote George Wythe, all these famous judges. So I think you need judicial review to be consistent with our checks and balances system.
I certainly agree. What wasn't the power of judicial review incorporated into Article 3 itself? It was, the Marbury versus Madison decision articulated it. Maybe it extracted from it being there implicitly, but wasn't explicitly stated in the Constitution.
Yeah, if you recall Marbury, Marshall says he's not doing anything original here. This just draws on general principles. So it was widely accepted. And if you read the framing and ratifying debates, they anticipated it would be in there. They knew about all of these colonial and early state precedents for judicial review, and there are a lot of them. John Marshall was in the audience for one of the big ones in Virginia before he became a Supreme Court justice. So, but in terms of why literally they don't say it, I don't know why they don't literally say it. One of the state constitutions was eventually amended to literally say it. None of them literally said it. And then one of them, I think it might've been South Carolina, but don't hold me that. One of them finally just literally said it. Courts have the power of judicial review.
Mm-hmm. Another question from our audience. They were wondering about what you concluded from your research about the different mentalities of historians and legal scholars, and how any distinctions you found illuminate their perspectives on the judiciary today. I guess, the different approaches of historians and legal scholars?
Yeah, that's a great question. I love that question. Actually, the conclusion of my forthcoming book is about that question. What do I, as a lawyer, bring to a story that's different from what a historian brings to it? And so what I think I bring to it is, again, a close attention to text and to the principles underlying the text. I think that's what lawyers bring to it. Historians are about context, and they sometimes, in my opinion, get lost in the weeds. And so I'm very careful, though, to have my work vetted by historians. Gordon Wood has now become a friend of mine because he reads all my stuff. And if he signs off on it, I feel pretty good about it. And but that's what I think the big difference is.
That's great. Well, I'm very interested in your new work coming out in July, Law and Religion and in Colonial America, the Dissenting Colonies. Do you want to give us a little preview of that?
Yeah. Well, after I finished the book that I just talked about, I was deciding what to do next. And I was having lunch, coincidentally, with Gordon Wood because I'd spend every summer at Brown until the pandemic hit. And then I spent a couple of years on sabbatical there, and I got to know him quite well, and he's a wonderful person. And so I told him that what I was thinking about doing was doing this book about the animating principles of early American law. So the kind of Montesquieu thing. So why was Virginia founded, for example? And what did the early laws do to try to advance that principle? Or when did they eventually, if ever, become inconsistent with it? And so Gordon told me, great idea, too big. Take a piece of it to see if you want to do it and to see if it's doable. So I decided to focus on the religion piece. So what I focus on in that book are the 5 colonies that were founded for religious reasons, either for religious toleration or to advance a particular religious perspective. So Massachusetts and Connecticut were Puritan colonies, and they were trying to create a perfect place for that. And then Pennsylvania, Rhode Island, and Maryland believed in religious toleration and were more welcoming of other folks. And so what I do in that book is I just explain that, but then the hard work is when you're talking about the laws about religion in each of those colonies, and how did the laws help implement that animating principle, and how did they eventually, in some cases, obviously in Connecticut and Massachusetts, extinguish the animating principle, because obviously in Connecticut in 1818 and in Massachusetts in 1833, they disestablished the Congregational Church and now have religious freedom. So that's what that's about.
Well, we look forward to that, and thank you very much for your current work and for this wonderful lecture tonight. It was stimulating and well attended, and we are sure are given the questions, and we welcome feedback from our audience. I'm sure they got a lot out of it, as I certainly have. Thank you for taking your time out of your busy schedule, and it was an illuminating conversation. I want to thank again our partners at the Justice Kennedy Library and Learning Center in Sacramento and the Judicial Learning Center in the 8th Circuit for working with us on these programs. We host monthly virtual, the Supreme Court Historical Society hosts virtual monthly lectures on the history of the court. Our next event will be held on January 25th at 7 p.m. when my good friend, Judge Margaret McEwen, will be sharing her new book on Justice William O. Douglas called Citizen Justice. And we'll have a great discussion about that work. Registration is open and available at the Society's website, www.supremecourthistory.org. We will be announcing the next Civics and American Democracy program soon in this new year, and registration for that will be up on the Society's website when we pin down the next date. A reminder to all who joined us tonight that a survey will go out tomorrow, and everyone who's registered in advance should receive the survey, and we hope you will respond to it. We want to make these programs as meaningful and accessible to as many people as possible. We thank you all for joining us tonight, and a very special thanks again to Professor Scott Gerber. Thank you, Scott.
Thank you, Jim, and thanks to Jennifer in the audience.
And with that, we are adjourned.